Mr. Kingsley, it's great to have you here today. We're going to get down to committee business now. Mr. Kingsley, I know you have an opening statement, and you'll do your best to keep it as short as possible because we have lots of questions for you. But welcome again. It's great to see you again. Go ahead and start.
Merci, Monsieur le Président.
Thank you, Mr. Chairman. I would like to thank the clerk as well as the interpreters and the translators who have prepared the text that will be distributed to you momentarily. So, good morning.
Nameless, who are good friends and colleagues who have worked days on end to help me prepare for this appearance. Honorable members du comité, c'est toujours
Honorable members, it is always a privilege to appear before you. I'm here today to speak about Bill C-23. I followed the appearance of Mr. Méran on CPAC, and I agree with his testimony. Canada's electoral democracy and our electoral agency, Elections Canada, stand second to none throughout the world because our elections enjoy the confidence of Canadians. They are built upon 5 values: participation, fairness, impartiality, transparency, and accountability. I have therefore evaluated the bill from their perspective. A number of the proposed changes in the bill will sustain the values underlying the Act. The provisions respecting voter contact calling services will help avoid the repetition of the infamous robocalls during the 2011 elections. And the committee should perhaps extend the period for the conservation of documents in order that it be of the same length. Moreover, the records should include the phone numbers of persons contacted in order to maximize their usefulness to investigators. This latter information would not become public and would be accessible only for investigative and prosecution purposes. The significant increase in potential fines for conviction of breaches of the Act, up to $100,000 for some offenses, along with the potential for jail time, will help enhance deterrence significantly. To further this end, I would recommend that consideration be given to additional fines. The provision of a 4th day for advance polling will benefit electors who increasingly vote in advance of polling day, a number in excess of 2 million Canadians in the 2011 election. The reformed legislated schemes for loans and unpaid claims will help ensure that rules concerning contributions are respected. The Advisory Committee on Political Parties will be established in law. This committee has operated since 1997, and it has proven an invaluable mechanism for exchanges between Elections Canada and all the registered parties, including the smaller ones, which often have a very different take on issues. Lastly, the new statutory provisions respecting interpretations and advance rulings by Elections Canada will benefit participants and the public, albeit the time requirements imposed on Elections Canada will have to be adjusted to the work table and be more workable.
Neutral in their effect. They are the decision to move the Commissioner of Canada Elections from the office of the Chief Electoral Officer to that of the Director of Public Prosecutions. This move constitutes an extension of the decision Parliament made in 2006 with the Accountability Act to transfer the authority for the prosecution of offences under the Canada Elections Act from the Commissioner of Canada Elections to the Director of Public Prosecutions. Parliament fixed a problem which did not exist. And it bears repeating, Mr. Chairman, that as a result of that decision, it has been the Director of Public Prosecutions, not the Commissioner of Canada Elections, not the Chief Electoral Officer, who has decided when to prosecute under the Act since that time. The Commissioner serves only an investigative and advisory role in that process. It has always been the courts which have determined guilt, not the Chief Electoral Officer, not the Commissioner, and not the Director of Public Prosecutions. In the performance of his investigative functions, the Commissioner has always operated independently of the Chief Electoral Officer and will continue to act independently of the Director of Public Prosecutions with the protections afforded those operations in this bill and in the Director of Public Prosecutions Act. What is lost is the simplicity of the previous enforcement regime, its cost-effectiveness, and the timeliness of prosecutions. The increase in spending and contribution limits is another one. Under the bill, spending limits will increase by 5% and contribution limits will increase by 25%. As well, individuals will be able to donate more of their own money to their candidate and nomination campaigns. This should increase their ability to meet their startup obligations, reducing their reliance on loans without seriously impacting the overall role of money in the process. There are aspects of the bill which will benefit from further consideration. Several changes are essential. The proposed exemption from a registered party's election expenses of those related to party funding communications with persons who have donated over the preceding 5 years more than $20 to emanations of the party is not justified. It is simply not possible to seek funds without including reasons for giving, and this can only constitute advertising for or against a party or a candidate. Moreover, it favors richer and established parties to the detriment of small and especially newer parties. Nor will it save taxpayers any money. The established parties will continue to spend very close to the newly increased spending limits and will be reimbursed accordingly. The only way to reduce the amount of the reimbursement is to reduce the election expense limits. Respecting registered party returns, your committee should consider vesting in law the authority of the Chief Electoral Officer to access and inspect relevant documents supporting the information on party returns when relevant. This recommendation has been before your committee previously as part of the report on the 38th general election, and it was included in Parliament's unanimous resolution of March 2012 in the wake of the robocalls scandal. Bill C-23 would certainly provide longer reach and sharper teeth should the authority to compel testimony be granted to the Commissioner of Canada Elections when he investigates breaches of the Canada Elections Act, as agreed as well in the 2012 unanimous resolution. The need for this authority, which is possessed by most of the electoral authorities in Canada and by many other federal agencies, is demonstrated by the apparent lack of progress in the robocalls investigation. Persons in position likely to be able to provide important information now know that they can refuse to talk to investigators. Well, their lawyers know. I would note in passing that this authority can only be exercised once approval is granted by a court upon application by the Commissioner. I would now like to address two vital matters which must be changed to maintain fundamental values of our electoral democracy. As they stand, these provisions will impact very negatively on the values of participation, impartiality, and transparency. Firstly, there is Bill C-23's proposed abolition of the legal provision whereby one elector can prove his or her identity through vouching by another elector. This will directly affect the constitutional right to vote of a significant number of Canadians without justification. Strict measures surround the vouching process under the Act, allowing those electors who present themselves at their designated poll without the requisite documentary proof of ID and or proof of address to establish them through another elector from the same poll who has already provided the required documentary proof to the satisfaction of the electoral officials. The voucher takes an oath that the voucher knows the person to be vouched for and his or her address. The person being vouched for similarly takes an oath. One can only vouch for another once, and a vouchee cannot vouch for someone else. In practice, in many cases, vouching is employed in circumstances where there is no risk. In the majority of the cases, vouchers are related to the person for whom they are vouching, and the person being vouched for may already be on the list of electors. Moreover, Mr. Chairman, vouching is often used where proof of ID is provided and proof of address is lacking. For example, vouching occurs on reserves which are defined territorially and where the person being vouched for already possesses a status Indian card, acceptable proof under the Canada Elections Act. Each reserve usually constitutes one or more polls, and consequently the possession of such a card could constitute sufficient proof of address. It does not, hence the need for the vouching process. Similarly, in the case of students, poll officials obtain certifications by university housing authorities concerning those who reside in their residences. Again, this does not constitute sufficient proof of address. A large number of vouching cases take place in institutional residences where Elections Canada sent revising agents as part of the targeted revision process during the election and determined who the residents are. Virtually all of these facilities are designated mobile polls when they don't already constitute a regular poll, thus amounting to a totally controlled environment where the required proofs are already in the hands of election officials. Mr. Chairman, the errors identified with the vouching process earlier in this committee have been administrative in nature, owing to failings of poll officials rather than being indicative of fraudulent voting. The resolution of this administrative problem lies in the simplification of processes, the rigorous application of the requirements by electoral officials, and the reinforcement of their obligations during their training. I note that the bill currently proposes to add greater certainty in circumstances where it appears at a poll that an elector's name has been crossed off the list in error, or it is purported that someone else has voted under that person's name. In such circumstances, the Canada Elections Act requires that the elector take an oath before being permitted to vote. The bill proposes to amend these requirements so that the elector will now be required to take the required oath in writing. Amending the vouching provisions to require that the requisite oath also be given in writing will address the concerns which have been raised respecting vouching. There is a fundamental inequity when a federal statute requires documentary proof of identity and address before one can exercise a constitutional right, and no federal agency provides such proof in one readily available form. Secondly, I wish to address Bill C-23's amendment to Section 18 dealing with the Chief Electoral Officer's ability to communicate with the public, limiting it to 4 basic voting elements: who, when, where, and how, touching candidates as well. The Chief Electoral Officer must retain the authority to reach out to all Canadians, to speak to them about our electoral democracy, the importance of our constitutional right to vote, and the methods and the values at the core of our electoral system. He speaks without regard to partisanship, while candidates and parties do so typically in a partisan manner with the legitimate purpose of obtaining their vote. Not a problem. The Chief Electoral Officer must be able to sustain important endeavours by academia, such as the Canada Election Study, and by NGOs such as Student Vote and Apathy is Boring. Total disclosure, I chair the latter's advisory council. We have a major problem of participation in our elections. Less than 40% of young people between 18 and 24 actually vote in this country right now. The Chief Electoral Officer must retain the authority to provide the information requested by the media and to share any information he deems pertinent with Canadians at any time. His overarching concern is the integrity of our electoral system. Any concern by a political party can be raised at the proposed Advisory Committee of Political Parties for consultation. It can also be raised at this very committee at any time. Let me be clear. Absent the rescinding of the proposed Section 18 in Bill C-23, Canadians will lose their trust and their confidence in our elections. That is not acceptable. With these changes, as proposed, Bill C-23 has the potential to maintain our electoral process and Elections Canada second to none in the world. Thank you, Mr. Chairman.